Hello, good afternoon, good morning, good evening. My name is Mpumelelo Chavalala, and mine is to welcome you to this webinar on excessive pricing, hosted by the George Washington University's Competition and Innovation Lab, the South Africa chapter. The lab is a thriving research institution that is for pioneering ideas in the realms of market innovation and competition law. Now, we have brought together multiple legal and economic practitioners in the field of competition law enforcement in South Africa. We have from the bar, who is practicing as an advocate, Mr. Katlego Monareng. We have from the attorney's profession, Ms. Laura Granville. We have from our regulator in South Africa, the Competition Commission of South Africa, Ms. Maya Swart. And then we have an economist who is working in private practice, Ms. Tembalethu Buthelezi. Now, each speaker has asked that I really enforce the point that they're speaking in their individual capacity and not on behalf of any of their employers or any party that they might work with. In instances where they were part of the case that they're about to discuss, they will endeavor to say so. Just to let you know, I might be popping up every now and then, and that's just to give an indication to our speakers about the amount of time left. So you may see my face appear once or twice in the background. Now, I understand we have both local and international delegates with us, and I want to remind you all that the South African Competition Act was amended with effect from 2020. Part of those amendments included an amendment to Section 8, the section on abuse of dominance, and the subsections on excessive pricing are what we're dealing with today. Now, there are divergent views, actually, and today we're going to explore those views. Going either way, that support the view that either these standards have minimally changed, and on the other hand, some people are saying that there's been a significant change as a result of the legislative intervention. Now, without further ado, I'm going to hand over to our speakers to give us the meat of the discussion today. Mr. Monareng, thank you.
Thank you, Mpumi. Good morning, good afternoon. My name is Katlego Monareng. I'll be discussing the topic on excessive pricing in the context of South Africa. This year, our competition law is 25 years old. And in these 25 years, our competition law in the context of excessive pricing has undergone what I term three phases. The first phase is what I refer to as the pre-amendment phase. And this is the period between 1999 and 2018. The second phase is the period post-amendment. And the third phase is the phase within the second phase, which I referred to as the COVID-19 pandemic phase. And most of the disagreement around the interpretation of Section 8 have been around the first phase of the implementation and enforcement of the Competition Act. There have been divergent views and disagreements, interpretational disagreements between the two specialist bodies that are responsible for the enforcement of the Competition Act and interpretation of the Competition Act. Those are the Competition Tribunal of South Africa and the Competition Appeal Court. In the first phase of abuse of dominance enforcement, there have been two important cases around excessive pricing. The first case is what we generally refer to as the Mittal judgment. And in that case, the tribunal had found that Mittal had engaged in excessive pricing conduct. And that case was then taken on appeal, and the decision of the tribunal was overturned on appeal by the Competition Appeal Court. So the real debate between the tribunal, or the real disagreements between the tribunal and the Competition Appeal Court, was on the question, or on the meaning of what it's been called an economic value. So just to give context, in the first phase before the amendment, an excessive price had been defined in the Competition Act. It had been defined as a price that bears no reasonable relation to the economic value. And as we all know, that definition comes from the European case in the United Brands judge decision. So the Competition Act borrowed largely from that judge, the definition of excessive pricing borrowed largely from the judgment of United Brands. But the problem that was there with the definition section, which led to the second phase, was the concept of economic value had not been defined in the Competition Act. So the debate was really, what did the legislature intended when they included the economic value in the definition of excessive pricing in the Act? The tribunal, in its first judgment in Mittal, understood the concept of economic value as something that is in the understanding that will take into account what they call cognizable competition considerations. And that is the basis that the tribunal used to find that Mittal was guilty of excessive pricing. In that case, they took into account the fact that Mittal they termed them as super dominant. They had close to 90% of the market. And Mittal was previously a state-owned entity. And barriers to entry in that market, which was a flat steel market, the tribunal found that the barriers to entry were very high in that market. So they termed the cognizable competition considerations as a structural test that they took into account that, given the nature or the structure of the market, Mittal was sitting in a position where it could price its product excessively. On appeal, the Competition Appeal Court disagreed with the Competition Tribunal. It understood that the concept of economic value means a notional price by a notional competitor in a competitive market. But when one looks at the approach of the tribunal in Mittal and the approach of the appeal court in Mittal when it was taken on appeal, there are really no conceptual disagreements between the two institutions, because all of them, the two judgments, appreciate that economic value means a competitive price. Then the second judgment, because of time, I'm not going to deal with it, because I want to jump to the second phase, which is the phase after the Competition Act has been amended, which to remove, because the controversy was around the meaning of economic value. The legislature saw it in its wisdom that definition should be removed in the definition sections of the Competition Act. What they have done now in the second phase was to accommodate the views of the Competition Tribunal in its judgment, in its first judgment in Mittal, and its views in its judgment in SCI, Sasol Chemical Industries. Also accommodate the views expressed by the Competition Appeal Court in both Mittal and SCI case. So now, instead of asking the Competition Commission and the tribunal to undertake or undergo through this difficult process of explaining what an economic value is, the amendment has provided guidance to the regulators as to how you arrive, how you define or understand what the competitive price is. There are factors that have been outlined in the Competition Act that the regulators have got to take into account in determining whether or not the price that is alleged to be excessive is higher than what has been termed a competitive price. One of the indicators that can be taken into account is the price cost analysis. And in Mittal, in the first phase in Mittal, the tribunal relied on what it termed the structure of the market. And that view has been accommodated now in the second phase in the amendment. In SCI, the tribunal had taken into account what it referred to as cost advantages or state support that SCI had received when it was still owned by the state. That factor, the cost advantage factor, has now been catered for in the second phase in the amendment. And the views of the CAC have also been taken care of in the second phase. And this is about the meaning of an economic value, or what the competitive price is. Because as we understand the judgment of the Competition Appeal Court in both Mittal and SCI, is that the price that you compare with is the price of a notional competitor in a national market. So that view, in my view, has also been accommodated in the amendment. So basically, what the legislature has sought to do with the amendment was to avoid a situation where, because economic value had not been defined, it had not been defined in the Competition Act. What the legislature sought to do was to avoid the situation where there will always be unending disagreement between the Competition Tribunal and the Competition Appeal Court, because there are a number of factors that can be taken into account in defining or explaining what an economic value is. So now it's clear in the amendment what factors got to be taken into account in understanding whether or not the price charged by the dominant firm is higher than a competitive price, and whether or not that price, the difference or the excess, is unreasonable. So I'll stop here. Thank you.
I hope the meaning wasn't misinterpreted. You actually have another 3 or so minutes if you'd like to continue. That was your 5-minute mark. But if you are complete, I can move on, Katlego.
Now I can touch on, because there are two important aspects that came with the amendment or the second phase. Firstly is the issue of factors that have been listed under Section 8.3 of the Competition Act. Secondly, the other important introduction in the second phase is what we refer to as the prima facie proof or prima facie standard. So what the amendment have introduced is that once a price has been shown to be excessive, the burden shift from the complainant or the regulator to the dominant firm to show that the price that is alleged to be excessive is not unreasonable or is reasonable. So those are the two important things that came out with the amendment to the Act in 2019. Thank you, Mpumi.
Thank you once again, Mr. Monoreng. Handing over to Ms. Lara Granville. Take it away.
If you can raise the slide which shows the difference between the two provisions, that would be great. Yeah, so it's kind of hard to understand the change that was made in the amendments without seeing them in front of you. And I'm going to talk about these changes, identify what the key elements are, run through some of the cases that, Katlego has spoken about, and point out that really nothing has changed from the old act to the new act insofar as a determination of excessive pricing is relevant. So it's worthwhile looking at these differences. In the prior version of the Act, it was prohibited for a dominant firm to charge an excessive price to the detriment of consumers. And an excessive price was defined as a price which bears no reasonable relation to and which is higher than the economic value of a good or service. You'll see that the provision post-amendment is far more extensive. The prohibition is the same. It is prohibited for a dominant firm to charge an excessive price to the detriment of consumers, the change being that it's added customers here. It then points out that there is a prima facie, in the case where prima facie case of excessive pricing has been made out, the onus shifts to the respondent to show that difference in the competitive price and its own price is reasonable. And then there's this kind of mishmash of all things in one in sub 3, which says it essentially defines what an excessive price is. It's a price that is higher than a competitive price, and unreasonably so. And then it says you can, for both the excessiveness and the reasonableness, one can consider all of these things. One is the respondent's own costs and prices, its own returns, so the profits it's securing on that. And then a number of comparators, the respondent's own prices in other places, or its historical prices or otherwise. Other comparators are the prices of other firms in competitive markets. It points out, and here's where it captures some of the structural issues which really play into the analysis of dominance, which is the length of time that those prices have persisted. Because if a price is only present for a couple of hours or a couple of days, then it's unlikely to be considered excessive unless it can be sustained. Without dominance, you wouldn't be able to sustain it, and without being sustained, you would probably assume that there's no dominance. And then it speaks about considering the structural characteristics of the market. Is there going to, is the structure such that this dominance is somewhat impenetrable, which allows that excessive pricing to take place? Interestingly, adding this additional point saying you can consider past or current advantages of the firm, which are not due to its own efficiency or investment. So I think you can drop the slide for the moment, and we'll go back into the weeds there a little bit later. But I think it's worthwhile kind of showing the progression of what is understood by an excessive price, both before and after the amendment to the Act. So, starting at the very beginning, which Katlego mentioned, is the United Brands case, which essentially gave us the definition of excessive pricing pre-amendment, or this concept of economic value. What happened in this case is United Brands sold bananas to Irish customers at a much lower price than it sold to customers in other jurisdictions. And the European Commission said, well, if you're sustainably selling to Ireland at these prices, all the other prices must be excessive. They didn't use the terminology excessive because the treaty talks about unfair pricing. And found that this was unfair pricing, together with a number of ancillary kinds of conduct that prevented anyone from arbitraging or otherwise. And so, but what's key here is that the ECJ overturned the Commission's decision because it essentially said you can't make this analysis without looking at pricing. You can't make the analysis without looking at cost and pricing. And here it's got quite a long quote, but it says sort of the court appreciates the considerable and at times great difficulties in working out production costs, which may sometimes include a discretionary apportionment of indirect costs and general expenditure, and which may vary significantly according to the size of the undertaking, its object, the complex nature of its setup, its territorial area, whether it manufactures one or several products, the number of subsidiaries, and so on. So there's this long list of very complex issues to determine, and in each one you're probably going to be making a call, do I use this number or do I use that number? But the ECJ says, in this case, it's not that hard, the sale of bananas, but in other cases may be hard, you nevertheless have to do it. Then moving on to the tribunal's decision in Mittal, which, as Katlego pointed out, was overturned by the CAC. And it's right at this stage, I'm not going to go into what its findings were, although I should probably point out that the tribunal's analysis was that if you can look at the structure in the relevant market that you're looking at, and whether there's any kind of ancillary abuse, then you can make an assumption about excessive pricing. So in other words, it said, if the market is, if there is such dominance that it's almost 100% monopoly and the market is uncontested and incontestable, and on top of that, the firm is undertaking some other kind of conduct which prevents others from being able to compete with it on pricing, then one can just assume that what it is doing is excessive pricing. And so you see here that the tribunal made much of the same mistake that the Commission, the European Commission, did in United Brands. It looked at a range of ancillary conduct and it said, and the structure, and it said, well, we don't have to actually look at the prices and costs. It sort of seems silly to say, well, how can you determine an excessive price without looking at prices? But the tribunal's reasoning was somewhat sound in that it noted that what we don't want, and the real fear in excessive pricing, is the regulator to step into the role of a price regulator. So the tribunal's theory there was that if you can identify structure and if you can identify ancillary conduct, that will allow the regulator to address the ancillary conduct and prevent that ancillary conduct, which should allow the market to kind of rebalance and allow for those excessive prices to be competed down. That allowed the tribunal to say, well, we're not even going to tell you what to price. We're not going to tell you this is too high, but this is slightly less than too high, and so on. So that was the tribunal's reasoning. But at the end of the day, the CAC said to it, that's not what the Act says. The Act says we have to look at the economic value and we have to determine something which is higher, and that involves looking at prices and costs. But it's important even at the tribunal stage in Mittal that the tribunal recognize that economic value equates to a competitive price. Here it says whether the price was the result of cognizable competition considerations, and I think Katlego also mentioned that. So it's right then that we know that really economic value is about a competitive price. And the CAC made this even more explicit. It said what the legislature must have intended by economic value is the notional price of a good or service under assumed conditions of long-run competitive equilibrium. It's also notable in the CAC's decision that, the introduction of comparators is not a new thing brought about by the amendments to the Act. The European Commission and ECJ had been using comparators. The CAC references the NAP case, where various comparators were considered: the NAP's own prices, its prices in other markets, and those of its competitors. And the CAC kind of re-emphasized this point that you would want to look at different things. What does the firm price elsewhere, or what did the firm price historically or otherwise? So again, the CAC sort of said, you have to look at prices, you have to look at other costs, you have to look at comparators, and so you can't determine economic value through any shortcuts. And because economic value equals competitive price, you can't determine a competitive price through any shortcuts without an analysis of prices. So to the extent that anyone argues that the wording in the amended Act allows for any of those shortcuts, that wouldn't be possible considering the jurisprudence at play. In SCI, again, the tribunal made a finding against SCI that it had priced excessively. This is in relation to propylene and polypropylene, which are the products that go into plastic production. And the CAC overturned the outcome. But on the really key issue, both the tribunal and the CAC had made the same determination, which was that one should look at the firm's actual costs, that firm's costs, in working out the price-cost difference, not necessarily the costs of a notional competitor. The CAC's reasoning is not really aligned with kind of 99% of its decision. But putting that aside, the point is that both the tribunal and the CAC used the respondent's own prices and costs for the analysis. It was relevant here because, as Katlego mentioned, the Sasol SCI's sister company supplied it with the propylene and polypropylene. And that sister company was a refinery which had been supported and was a state-owned entity for many years, and used a unique a process for production, which meant that the kind of value of the propylene was lower to it than it was to others, and therefore it sold that to SCI at a lower price. Sorry, that might be a little bit too complicated. It's a very long judgment with quite a lot of boring discussion about cost determinants and fuel pricing. But the upshot is that this decision aligns with the changes to the Act, which reference the respondents' own prices and talk about historical support that was provided to the respondent. So again, this is pre-amendment. These are considerations that were in any event the law, despite the reference to economic value rather than competitive price. Katlego's third kind of phase here was the COVID world. What's relevant about the time of COVID is that the minister issued regulations which were notably called consumer protection regulations, which said, well, if you, the competition authorities, have a price gouging case before you, where someone has alleged that a firm has taken advantage of these pandemic circumstances to hike up its price, then you should, then as long as you, unless there is a cost justification for any increase in prices, then you can assume that the pricing is excessive. Now, Diskem and Babalegi, which are the cases that were heard on this issue, actually the complaint periods preceded the regulations. But in fact, both the CAC and the tribunal essentially apply the regulations anyway. So it's important to note here that the courts were at pains to emphasize the context of the COVID-19 outbreak. For instance, the CAC conceded when it looked at notably this is in the time when the amendments have taken place, the CAC conceded when one considers the length of time of pricing to see how persistent it is, that it might be different in COVID circumstances. So if you can retain a 10,000% price increase over a month in COVID, that might be persistent enough in that context. But it did note that that would not necessarily apply in a different context. Another important note on these COVID cases is that, this is my argument, which is that they were essentially consumer protection measures cloaked in competition law clothing. Although they said that we can't apply the regs retrospectively. The Commission's founding papers were based on the regulations, and the CAC, for instance, determined that the test it would use in Babalehi was to look at what the firm's costs were, and there had been no cost increase because Babalehi was not able to point out how much it really expected costs to increase, and because those increased, it supplies costs to increase, and because those costs had not yet increased, it was not justifiable in the circumstance. And this is essentially the application of what the regulations provide. So sort of wrapping this all up, and can we open that slide again just so that we can kind of see where we are? So let's start at the beginning. Dominance was a requirement beforehand, and dominance remains a requirement now. 8.3 adds specific structural considerations to apply, such as market share, contestability of the market, and so on. That's the same kind of analysis one would use for defining a market and determining dominance in any event. So there's been no change there. The court's decisions in the COVID-19 cases sort of flipped dominance on its head. It said, in these circumstances, in these pandemic circumstances, if you're able to increase your price by 1,000%, we can basically say you're dominant because you're behaving to an appreciable extent independently of your customers and competitors. But despite that flipping, as I've just pointed out, there's no reason to think that outside of pandemic circumstances, the tribunal or anyone would apply such a definition of dominance. So that's essentially the same. Then if you
more seconds, Laura. 30 more.
Sorry?
Seconds. 30 more seconds for you.
Oh, only 30 more seconds. Okay. I'm going to jump right to the end because I've kind of noted these throughout my presentation. But the one thing that people might argue is a real difference is this flipping of burden, saying if the Commission can show prima facie there's an excessive case, then it's the respondent's duty to show it was reasonable. And I don't think that really shifts the needle because the respondents would in any event lead evidence on all of these components. But it's interesting, but in those circumstances, one has to ask the question, why are we shifting the onus? And I think here that it might be a policy reason, which is perhaps there's an intention to shift the underlying philosophy about excessive pricing regulation. It's always been that you would be more reluctant to make errors and find excessive pricing present than let what might be cases of excessive pricing go free because one doesn't want to disincentivize innovation and investment, which is somewhat the essence of creating competitors in the market. And so that might be the intention, but that's not really the impact of the amendment. And then finally, I just note that regardless of the change, one's going to have to dig into the weeds. One has to work out what prices are, what costs are, what comparators are. Nothing makes the idea that this makes prosecution of excessive prices excessive pricing any easier is sort of farcical, because you're not going to get away from ticking the boxes and crossing the T's and dotting the I's. Yeah. Thanks. Sorry, I went
Thank you. Thank you, Laura. So I will swiftly hand over the mic to Maya Swart. Thank you.
Good afternoon. I'm Maya Swart. I'm from the Competition Commission, but of course these views are not the Commission's views. And just to state up front that I was personally involved in the Sasol Polymers case, or the excessive pricing case that went to the CAC. And also I'm going to just briefly touch on the blue collar case where I was also personally involved. So I believe, in my view, the deletion of the term economic value in the amendment and the replacement thereof with competitive price is not without significance. And I would argue that, for example, the reference in section 8.3a to the respondent's price cost margin, and not, for example, the price cost margin of a notional competitor under conditions of long run competitive equilibrium with free exit and entry, is also significant. And the amendments basically offer an opportunity for the competition authorities and the courts to reset or recalibrate the legal standard for excessive pricing to be purpose fit for a developing country such as South Africa, and to an opportunity to give proper weight and consideration to the purpose of the Act, particularly post the Constitutional Court decision in Mediclinic, which has enjoined competition authorities and courts to interpret the Act in a manner that promotes the spirit, purport and objects of the Bill of Rights. These sentiments were also echoed in the Competition Appeal Court's decision in e-media. Prior to the amendment, the wording of the Act and the reference to the term economic value, as was pointed out by the other panel members, was closely linked to the EU decision of United Brands, and in Metal and Sasol Chemical Industries, the Competition Appeal Court relied on EU law to interpret the meaning of economic value. The amendments allow the competition authorities and the courts to move away from the legal standards set out in United Brands, Metal and Sasol, or at least to set itself free from some of the inconsistencies in these agreements. So why is there a need for recalibration of the legal standard? I would argue this by way of reference to the CAC decision in Sasol Chemical Industries. There, the central debate turned on the interpretation of Metal and the treatment of Sasol's feedstock cost advantage within the context of its history of state support. In the tribunal's view, there was no justification for the elimination of the low cost of feedstock propylene from the evaluation of economic value. And the tribunal held that it was not legally justified to exclude Sasol's special cost advantage from the inquiry. Sasol in turn argued that the low-cost feedstock propylene was a special cost advantage, meaning that the cost of feedstock had to be adjusted upward in determining the economic value. And its expert testified that the competition in markets only eliminates rents that are not firm-specific, and firm-specific cost advantages are not transferred to consumers by the competitive process, and firm-specific rents associated to firm-specific advantages are compatible with the long-run competitive norm. This means that rents or profits that derive from the so-called special cost advantages are not passed on to consumers and are retained by the dominant firm over and above its return on capital and investment. And it should be considered in a context where we often have, not always, but often have markets which are uncontested and uncontestable. Sasol submitted that a firm with a unique cost advantage would have no incentive to reduce its price down to its own cost, as it could effectively compete at its competitors' costs or capture the entire market at a price only marginally lower. The tribunal had rejected the evidence of its expert that that long-run competitive equilibrium mean conditions of free entry and free exit from a notional competitor of a notional competitor in the relevant market. In the tribunal's view, this assumption was fundamentally flawed because it disregarded the fact that the very basis of the complaint is that in that market there is never going to be more than one firm and therefore never going to be effective competition. The competition on its side actually argued for a downward adjustment of the feedstock price to be cost reflective. And the Commission made an argument with regard to special cost advantages that if there is a particular innovation of risk taken by the firm, then this would be something that they would have a return on. But it doesn't seem justified that you would be able to reap a return on something which doesn't require any innovation or investment on your part. This interpretation, however, seemed to be inconsistent with the examples of special cost benefits mentioned in Mittal, which seem to allow any advantage, whether current or historical, whether it was the result of its own efforts or not. And strangely enough, the CAC did not resolve this dispute, the central debate, with reference, this is now in the Sasol Chemical Industries matter, it doesn't resolve this debate with reference to the principles that it itself set out in Mittal. It held that in this case, therefore, if the cost of an essential component of the production of product whose prices are under scrutiny can be justified on rational grounds, that should be the yardstick employed in the primary inquiry with and it stated that the complexity of price assessment dictates some difference is required, and that's difference to the firm. The CAC accepted a feedstock price which represents the price which Synfuels sold feedstock to Sasol Chemical Industries, and it specifically held that there is no basis to adopt a hypothetical price divorced from the reality conceded by the appellant and which would gut any possibility of prosecuting an excessive price. So the CAC and Sasol did not relate any of its decisions on whether to prefer Sasol's position over the Commission's position on the determination of the ordinary cost of production and the economic value back to the principles set out in Mittal. And in the end, we end up with two conflicting Competition Appeal Court decisions. In its application to the Constitutional Court for leave to appeal, the Commission made the following points, which is appropriate. Firstly, in relation to the determination of economic value, the CAC relied solely on the economic value that it had determined by reference to the notional cost of production, with no regard to its statement in Mittal that there are a number of permissible methods of establishing economic value. Secondly, in determining economic value by reference to the ordinary cost of production, the CAC included a number of costs that were not, as a matter of principle, such ordinary costs, and these included Sasol Chemical Industries' own required rate of return rather than the normal rate of return that a firm in the market could expect, and the value for which Sasol Chemical Industries had insured its assets rather than the ordinary value of the assets measured by reference to the cost purchasing them. And thirdly, in assessing the reasonableness of the relationship between Sasol Chemical Industries' prices of propylene and economic value, the Competition Appeal Court imposed a minimum threshold of 20%, despite its statement in paragraph 43 of Mittal that in some circumstances no amount of profit at all above economic value might be justifiable. And unfortunately, the Constitutional Court declined to hear the Commission, and in the circumstances, a fresh start or recalibration of the legal standard is clearly required. I would argue that in the future, the Commission would be able to rely not only on the price cost test, but also on other methods to establish the competitive benchmark, like we saw in the Dischem decision, where the regulations were not yet in force at the time of the impugned conduct, and it was accepted by the tribunal that an excessive price can be determined by comparing the respondent's margin to a competitive margin, and considering whether such difference is unreasonable. It was accordingly accepted that the competitive margin could constitute a competitive price, and the competition authorities can also carefully consider what it considers to be special cost advantages and whether it is appropriate for dominant firms not to pass on any of the rents or profits derived from these cost advantages to consumers. I would submit that an overly inclusive interpretation of special cost benefits can inflate your economic value or competitive benchmark to such an extent that you may never get to a reasonableness test. I would also like to point out that even in the Sassel matter at paragraph 102, the court refers to its paragraphs 49 and 50 of the Mattel case and states that where the actual price is shown to exceed the normal price for roughly similar products to a degree which is on the face of it utterly exorbitant, then the need to quantify economic value more precisely would, before concluding that the actual price bears no reasonable relation to it, may fall away. In this way, a prima facie case would have been made out, leaving it to the respondent to adduce evidence to the contrary. Likewise, where the dominant firm raises the normal price for its product substantially without any corresponding rise in cost, this may indicate prima facie that the new price is higher than the economic value without the need to quantify the latter more precisely. So these methods of establishing, or shortcuts as some people refer to, of establishing a prima facie case, I would argue would be available to the competition authorities, and it was actually included in the Competition Appeal Court decisions, although it ultimately ended up ignoring those alternative assessments of economic value. So, and then I would just briefly touch on the issue of reasonableness. Prior to the amendment, the factors which could be considered under reasonableness were so-called cost justifications and were fairly limited, I would submit. And the amendment may, however, in future be interpreted to include more factors as long as they are considered to be relevant. In the blue-collar matter, which was a price gouging matter, the expert for the respondent, for example, argued that gender also matters, as OECD research shows that women-owned businesses are more likely to disrupt cartels, and that enforcement against blue-collar as a black and female-owned SME could have negative consequences in that it would deter future entry from similar businesses. The tribunal, however, did not specifically deal with these arguments and where they would slot in the assessment in its decision. But I suspect we could see similar arguments being made in future, including potentially arguments around pro-competitive gains or public interest benefits. And that's my view.
Thank you, Maya. It's getting harder and harder not to express my own views and take liberties. I am going to switch over to Thembaletu, who is our economist on the panel. Over to you, and hopefully I'll be able to provide some insights at the end.
Well, hopefully I'll say what you want to say. Let's see how it goes. Thank you, Mpumi. I think I have maybe about four main points to make. And it's nice that I'm coming in after the lawyers have really taken us through quite a bit on the case precedents and where we stand. I think perhaps it might be worthwhile to begin the economist's positioning on this by first just really looking at the track record that the South African authority as well as the courts have had in terms of their consideration of excessive pricing cases. When you look at the count, I think there's probably about 5 cases in, over this 25-year period, purely on the excessive pricing that have been through. There's about, and maybe my numbers might be wrong, but at my last count, there are about 8 that are in the waiting line, so still to be heard by the tribunal. And of the ones that have been heard, the commission as well as the tribunal have not been very successful in, and success being upholding a prosecution of excessiveness. There is one case that was settled, but, that was settled between the parties. And so when you look at it from that positioning, it does at least certainly start to indicate that perhaps, there is some warranted need for what the amendments have brought forth in terms of the legal standard. I think a second positioning is also to consider where the economist and economic analysis is required here and what the role is. Because certainly you do need clear legal standards to give very important framing to how the economic evidence is shown and how the analysis and what the analysis rather is required. And it's important to approach this from that positioning of what the legal standard gives to this by explaining what the test is. And as we've heard, a lot has been said about learnings from Mittal and particularly some of the price gouging cases and what the COVID experience did give to us or not give to us from a precedential value. Just personally, I think the value of what we're getting from the legal standard is just distilling in a way the essence of what you are required to show and to think about from excessiveness. And if we take it back to the start in terms of how Katlego and Laura did mention in terms of the Mittal case, in essence, it was a question of, are prices moving in a way that is justified by the costs of the company? And that, in a way, is the distilled question of what we're trying to understand here from an excessive pricing perspective. And I do think there's value in that, in questioning the price relative to the cost and what do we come out to. And the COVID experience did try to do this in one way, but it did do this backed by what the precedent was saying in terms of what Mittal proposed from the data. I think the third point to make, which is where if we look at what the amendments have tried to do, I think certainly there was almost an agreement that there were very problematic terms that were included in what the old provision of excessive pricing required from us. So economic value, not defined, precedent had different ways of coming to that finding. Reasonableness as well, not defined, change per market, depended a lot on what the firm-specific facts were, and how to consider that was also very much unclear. Now, what the amendments have done from an economic perspective and what's been useful is that it's adopted language, which I believe is closer to what economic principles or thinking are when we're talking about excessive pricing. So now, when we're talking about excessive pricing, it's simply just the price above a competitive price or the competitive level. And that certainly takes us back to at least some comfort in terms of what Ecos 101 requires of us. So it begets the question of, well, what is a competitive price? And then we go back to our principles of, well, what is perfect competition and how does that work and what price comes out of that kind of economic outcome? And there, when we talk about perfect competition, it is really markets in which entry-exit is seamless. So if you have a perfect competitive market, you're talking about entry-exit being quite seamless. And the market can correct for itself in that way. And this is where, I had a nice laugh listening to all the lawyers talk about this long-run competitive equilibrium price. And we learned that from Ecos 101, that point, that tipping point, and those wonderful cost curves that all of us used to draw, that is the point of competitive price. But how to construct this, and particularly how to construct this in markets in which barriers to entry are significantly high. And all of the cases that the tribunal has heard, none of those cases have been in a market where you have this entry-exit being as seamless as what the concept requires of us. And in those markets, it's even an additional burden to consider that there is no actual counterfactual price where you have this competitive outcome that you can easily pull from. So that already, from an economic perspective, does push, well, what am I required to do? And of course, now the amendments have borrowed from the precedents, and we got quite a nice lesson in terms of what SCI said. Respondents cost themselves. You can look at prices in other markets, and we've gone through almost those elements. But I think if we think about practically and in terms of what you're required to calculate, I don't know if we're really at a very different position to what the old provision had, where there was economic value, at least now I benefit from talking about competitive price, which is, intellectually and I guess from an economic perspective, a concept that we have not heard about, and it is well grounded in competition in terms of what's required. But I think practically the same kind of considerations are in place of how do I get to this point of what a competitive price looks like, particularly in a market where there has not been this competitive equilibrium point. And I think there, if your question, Bumi, that you put very nicely at the beginning of this was, the more things have changed, we've had some changes, have we really changed, or are we at the same point? I think there my answer to is that I think we're still kind of standing at the very position that we were at the end of SCI as a competition field, in that it's still not very apparent in terms of how to practically and competitive and the calculation to get to what this competitive price is. We're told we're required to get there, but I think certainly the amendments haven't really moved us to a better positioning on what that and what the key components to that are, particularly in light of the markets that we are facing in South Africa. And I think that context is very important to not forget. I think also married to that point is there's been a lot of scholars, economic scholars, because, as economists like to play a little bit in this legal field, that you can actually even look back to a lot of work that Motta did 2003 and some Vickers did as well in 2003 in terms of considering grounds of intervention for excessive pricing. And there's a lot of factors to consider here, but I think two very important factors where I think the amendments haven't really captured this idea is it is well known from economics that markets are not self-correcting, and particularly South African markets, that market failures do exist. And that we also are looking at markets where there are significant barriers to entry. So marrying this idea of competitive price and this notion of competitive equilibrium in such markets, I think, doesn't really move the dial in terms of what we're required to do. So my proposal, and this is my last point on this, is that, I think it depends who you talk to, but I think certainly from an economic perspective, I don't believe the dial has moved too much, because as Lara said, we are required to tick through all those boxes, but I think the boxes are still remain as unclear as what they were prior to the amendments. I do think that maybe what could have been useful from an economic perspective is in a way to almost the learnings that we get from how the European Commission and the standard that they've put in. So less of a competitive standard in terms of linking excessiveness directly to a competitive price in this way, but to also maybe borrow or thinking about this unfair pricing or unfair standard that's associated with that. I think that kind of language where we're looking at the price that we're seeing in the market comparing to maybe an unfair selling price, indirectly or directly, does in a way allow a little bit more flexibility in terms of linking market dynamics to the conduct, the excessive pricing that you are considering in that instance. And I think there's a little bit more flexibility, because certainly when we look at the cases that have been put through to the tribunal, a lot of the markets that we are talking about, regulated markets, markets with patents in some instances, markets where we've had really heavy state support, it's hard to marry the idea that, amendments that speak to competitive pricing, borrowing from competitive equilibrium, if you truly understand what the concept requires, I'm still yet to be at a point where we can actually get to that calculation that we're required to make if you read the legal provisions and you understand the economic principles at that level. Thanks a lot, Mbu.
As a lawyer, I will uncommonly say I valued the input of an economist. That was very, very insightful. And it is for me to wrap us up, as we have about 30 seconds remaining of our webinar. And what is sticking with me as a final point is this idea around whether the new Section 8 was really a codification of jurisprudence where it was at the time, or whether we are enjoined, just as statutory laws tell us, to consider changes to laws as being significant and for a reason. And if that is the case, then we need to imbue some kind of value to these new words that have been added to the text. On that note, I will stop us at 1 hour. Thank you ever so much to all of our guests that have joined us. Thank you to our speakers who've really given us an insightful window into their thinking on the test, old and new. And of course, part of this task is that we are going to be making the law as we go. So part of this thought leadership is to inspire debate amongst ourselves and our attendees about where the law actually should go, because I think that the aspirant character of our law should always be imbued in the way that we interpret it and enforce it. So thank you to everyone who's joined us today. Have a pleasant afternoon if you're in South Africa, and enjoy the sun if you are in South Africa. Thank you. Thank you very much.